let me just make one final point, and that is that the United States right now leads the world, by far, leads the world in the technology industry and in the internet industry, right? It's not France, it's not India, not China, it's us. That's not a coincidence, right? We lead the world in the industries of the future because we made certain choices as a society, because our policymakers did certain things. 200 years ago, we had a First Amendment. Nobody else has a First Amendment. We prize speech. 20 years ago, the Supreme Court came out with a Betamax decision and said that if a product has non-infringing uses, it's a legal product, right, which accounts for the majority of what you see when you walk into a Best Buy. And then in the Digital Millennium Copyright Act, we created the safe harbor system, which basically said to somebody who's going to start an internet business, some sophomore is in her dorm room, look, go forward, start your business, get going. You won't get sued because if something infringing appears in your site, you'll get a notice. But if you take it down, you're fine. So go forward, build your business, and prosper. And because of that system that we set up, our internet industry has exploded because we gave it the proper context. What this would do is take that entire context and the liabilities and just turn it on its head and just fundamentally undo the safe harbors in the DMCA that have allowed the internet to grow and succeed. So before we do that in some kind of backdoor way, we need to give that serious consideration and serious thought and really consider the impact that it will have on the internet industry and on the economy. Because at base, this is a jobs issue. And if we proceed on this path, it will mean less investment. Venture capitalists have said this. Fewer startups and fewer jobs for Americans, and that is the last thing we need to do at this time in our history.
I think that's a perfect way. Let's open it up to questions.
I've heard a couple people mention alternative piece of legislation. Do you know anything that's coming together?
Because of the speed with which this thing's been moving along from the time that Lamar Smith dropped the bill, we haven't fully vetted it. But just to understand, there's some principles we think occur. First of all, that to the extent the government's going to get involved, we want to make sure that it not go just generally to the federal courts. Second of all, if injunctive relief, both against a foreign entity, which you cannot enforce, and against the follow the money participants, is to be granted, we think that appropriately it should be limited to that. If your job is to take it down, then your job should not be to threaten people's law-abiding sites' very existence with large monetary damages. The preliminary area that I happen to be working in is looking at the jurisdiction of the ITC, which falls under another committee, Commerce, because the ITC has worked for a long time on intellectual property. They have the expertise. They bear only injunctive relief by definition, and because they're administrative law judges, they have two advantages. First of all, they're fire and forget. A party does not have to be wealthy in order to come, bring a presentation, and if accepted, that case goes forward without any additional cost on the moving party, which is good for the small intellectual property holder. On the other hand, you're dealing with administrative law judges and prosecutors who, in fact, go through this constantly, understand the issues, and they're very much going to understand, for example, that the party that brings the case will have to show they own the asset. Under the existing legislation, they don't even have to prove you have the rights to the copyright to, in fact, initiate. So some of the elements would inherently be in it. As a member of the Judiciary Committee, it's always hard to suggest an alternative, but when I look at a court of specific jurisdiction of intellectual property that was formed to deal with foreign entities that do not have substantial assets in the U.S. and whose power is quick injunctive relief, I at least see a basis for a different approach that we want to have vetted by both our committee and also, obviously, Ways and Means that controls that committee.
Can you identify yourself when you ask your question? Thank you.
Lynn Stanton, TRDLE. On the issue of the proposed alternative legislation, it sounds like you'd still have a private right of action in it, in the way you described it?
Well, no, the ITC doesn't have a private right of action per se. The moving party initially in the ITC normally would be a patent holder saying, look, somebody's importing something that infringes my patent. They may participate as a party. They're not literally, they're sort of ex parte in a sense that they present information, But the ITC has its own counsels. They pursue a case that they believe has merit. They may determine that, in fact, your patent's invalid. They can invalidate a patent that, in fact, somebody came. So the idea that they represent just one side is not the case. They do tend to have two mandates, though, under their law. One is they represent a domestic entity that has domestic rights. Two, they only serve to stop foreign activities that would otherwise not be stopped, because a normal federal court can't do very much and very quickly. The idea, though, is there are no money damages, and we envision that the ITC would have continued jurisdiction. And I think here's the important thing. If you want to go to a federal judge and you want to say, okay, I've got my injunction against Whack-A-Mole number 1, and then there's a new entity, it is very difficult to get back to that judge in an expedited fashion. We envision that if the entity created one or more alter egos, it would be a short trip back to the ITC. They would their counsels would make a recommendation that these are in fact the same entities previously covered by an injunction. So you could have, by definition, continued jurisdiction to where the first process is quick, but would meet the requirements, assuming that somebody responds to the allegations. If there's a default, that would be the end of it. But if they respond, it would still be quick. The ITC is known to have a rocket docket. But then if what you have is alter egos coming again and again and again, or new ways of the money, you'd have a portion of commerce with a vested interest in moving quickly, and administrative law judges who by definition are probably more appropriate than your regular district court judge. So it's the speed, continued jurisdiction, a lack of money damages, expansive jurisdiction to enjoin, and the idea that by definition they would have continued jurisdiction. More importantly, they have a very close relationship and a good record with the Fed Circuit when there are appeals. So remember that not everyone who says this is my property is their property, and you want to make sure that that portion has a short cycle. I'm not saying this is the final alternative. What I'm saying is there are so many possible, less burdensome to the courts, systems that we should explore, that we want to at least begin having a dialogue across the Congress, because this isn't a new problem, and it should not be a problem that you say suddenly is ripe and has to be fixed in a matter of weeks. And that's where this was going before concerned citizens in and out of government got involved.
If I could just to clarify, ITC is International
Trade Commission. And what's important too, and I will say this, anything we do will be looked at around the world for whether or not we are being fair and consistent. We all understand that in China, a similar approach would take down Google altogether. So we want to be very careful to make sure that we have international buy-in, which is one of the reasons that I do think we have to build off of a base of known successes that are accepted.
Grant Gross, IDG News Service. Some of the sponsors have said that the opponents are sometimes overstating the problems with the bill. Some people have said it would break the internet, and some other issues that they think are overstatements. Anybody address that?
I'm talking too much, but let me just give you the congressional. They're right. We're overstating. There will not be pure apocalyptic event. However, when you look at the size and the growth and the benefit the internet represents, a couple of % change is material to tens of thousands of jobs and a huge part of our GDP. So you don't have to have an apocalyptic event for this to be too expensive and too dangerous to fire and hope for the best and figure that a year or two goes by before you fix it. So there is a reason to get it right, and it's the size of it. We would no more claim that we had to overnight change aircraft, every aircraft in America, without looking at the legacy of continued air travel. And we shouldn't do that in an industry that's far larger than the aviation industry. The internet represents so much of commerce that one might say all commerce is now dependent, at least to a certain extent, on the internet. So it's a very important reason to make sure that just my invoices from a company that's selling X product, all of that could fall under this it doesn't have to fall under it for it to be too expensive to take chances on.
Gigi, I
I
think,
just,
I think Gigi and then Ed.
the one thing that the proponents of this bill have absolutely not done is counteract the report by four or five of the most noted internet engineers about how this would destabilize the DNS system, how this would not permit the implementation of DNSSEC, which is intended to make the DNS system more secure. They've absolutely not done that. They've had no technological studies of their own. What you hear from them is pure rhetoric. When we say this undermines the DMCA or turns it on their head, do they actually demonstrate where it does not? I can actually show you the provision where it does, all right? So a lot of what we see from them is hand-waving, you know, while they talk about, well, this will just allow the Attorney General to do A, B, and C, they completely ignore the private right of action. They ignore the immunity from voluntary actions by intermediaries to, you know, to take down content based on reasonable belief. I mean, this is it's not 80 pages, it's a 78-page document, all right? This is, I agree with my conservative friends, this is regulating the internet. And there's no two ways about it. So, you know, I've seen very few specifics from the other side other than a lot of hand-waving about, oh, how we're just, you know, we're just overstating things.
Well, and I would also add, for those of you who have not seen this letter this morning, there's some companies that you may recognize who do think this is a pretty serious, pretty bad bill.
Yeah, let me echo, I won't duplicate what Gigi said very well about security, but the economic underpinning of the internet, the dynamic of investment, the fact that, you know, big companies are going to have a huge problem with this, but let me tell you, small companies will be devastated by it. And small companies on the internet have twice the income, twice the revenue flow than companies who have not learned how to use the internet. It's a big, growing, and key part of our economy. The one section, there's about 14 major definitional terms there, which we don't know how they will play out. So in terms of legal uncertainty, this is a jack in the box. We do not know how it will play out. And that, when you're talking about companies with major revenue, General Counsel has only one kind of advice: be safe, don't do X. Okay? Set up, basically, this will foster and incentivize companies to create a private censorship regime. It is, if you will, a government transfer of censorship, creating a censorship regime and privatizing it to companies. We do really think it is not part of the existing internet world that citizens expect all their internet companies to be part of a censorship regime over them. And yet that is the safe thing to do for companies who face this kind of liability. Let me just use one of those 14. When Section 102 and 103A both use words enable and facilitate. Enable and facilitate, these are big words. These are encompassing words. It would mean that iPods, personal computers, VCRs, computers, photocopiers, countless consumer electronics, all they all enable or facilitate. They do. I can't deny it. So they would all be covered. Now that is, you know, maybe I want to contradict the concept of apocalyptic, but it's devastating.